I wrapped the bitch around the tree on purpose. I don't give two F's anymore. And that kind of conduct continued throughout the entire process. Allegedly, he told the victim in the case, I'm taking the vehicle because I pay for it. I don't know how you pay for it under less than $1,000 of disability. So you're not getting the treatment you want on your own, and you're violent, drunk, and you resist police officers, and you become quite uncontrollable. Our next case this morning is People of the State of Michigan versus Andrew Young. The case number here is 36-3672 FH. Looks like he'll be coming over from the jail. In the meantime, let's go ahead and take appearances, please.
Thank you very much, Your Honor. Attorney Robert Ration, Assistant Prosecutor from Stockton County.
Robert Hartzell for the defense. My client will be joining us shortly.
All right, thank you. That's at the table next to defense counsel.
This guy crashed his car drunk, fought with police, and this was on top of a domestic violence charge. But the real story here is what the judge says next about the mental health system completely failing this guy, and he's not wrong.
Also before the court is Mr. Luke Blazak, the agent from the Department of Corrections, who is the author of the pre-sentence investigation report. We're here today for a sentencing in this case involving a conviction, 2, assault resist destructive police officer, operating while intoxicated 2nd, and domestic violence 1st. Mr. Ration, does the prosecution have any amendments, corrections, objections to make to the contents of this report?
We do, Your Honor. CFJ 284, page 5.
Okay, I am there.
The second paragraph, it says MSP labs confirm the presence of 0.012 gram of alcohol. That should be 0.138.
0.138. Any objection to that, Mr. Hartel?
No objection, Your Honor.
All right, that will go ahead and be made. Anything else, Mr. Ringstrom?
No, Your Honor.
Thank you. Mr. Hartel, any amendments, corrections, objections to make to the content of this report?
None, Your Honor.
Great, thank you. Allocution, Mr. Ringstrom, we'll go ahead and start with you today.
Your Honor, the defendant did cause big disruption that day. He wanted to get into the vehicle after drinking driving. According to him, he purposefully crashed into a tree. He did not follow officers' directions and then tried to get out of the vehicle and did get out of the vehicle afterwards. And he could have posed a risk to the entire society as a whole with his actions. He got a, in my opinion, very good plea bargain based off of the idea that we did not charge him taking the vehicle or personally crashing the vehicle. That in a large part had to do with the victim not wanting any of those charges being brought or anything like that. We are asking for the $100 restitution through the Sheriff's Department that we normally do. My understanding is there is no other restitution that is being requested.
Thank you. Mr. Hartel.
Thank you, Your Honor. Due to this case being no contest, I won't allocate about certain aspects of it. I'll encourage my client, based on my prior conversations, to most likely not make a statement about that part as well, though I would encourage him, if he wishes to make statements about his life moving forward and his plans. I know he was more than willing to talk to our office social worker, who I do thank for submitting the medication report.
And I did read through that, and I made several notes throughout the report.
Thank you, Your Honor. Without getting too much in detail on the record, because I know it's on YouTube, my client is aware of his mental health aspects and that all this phrase that self-medication is not the best way to go when you're dealing with, really for anyone, but especially when you have mental health. He's been to Pine Rest, places like that. And I'll just leave it at that because I know the court can see where he submitted. Mm-hmm. But I would ask the court to consider going on the low end of the guidelines, releasing him with time served and probation. I did have a chance to look over the victim's impact statement that people did. Let me take a look at that before it was submitted to the court. I won't go into too much about what I read because I don't believe that's my place, but I do believe that it's appropriate for the court to factor that in as well. If she wishes to make a statement, that's entirely up to her. But again, I do believe this is one where we're focusing on treatment is appropriate. Perhaps as terms of the probation require him to go to inpatient treatment. He has expressed a desire to do so. I know our staff has worked with him. They didn't quite get him to a location. Obviously, he's not in the Zoom from there, but he expressed with me as of late last week a desire to do so. And if the court wanted to make that determination, he'd do it. If the court wanted to make it a term of his probation to comply with mental health, he has every desire to do that anyways. We realize it's not just one thing, it's an entire lifestyle, and addictions and mental health are both things that are going to haunt him for the rest of his life. With the right support structure, I don't doubt he can make it. I ask the court to give him the opportunity to prove that he can. Thank you.
Thank you. All right, Mr. Young, you have the right to make a statement before I issue a sentence. Is there anything you wish to say?
If I was to be released today, I plan on getting a hold of my psychiatrist and going to her office for substance use counseling. So,
Okay. All right. All right. Well, this is a difficult situation. The law says the court is to use probation where it thinks that the defendant is entitled to probation. However, if probation does not appear that it's going to work, the court need not give it, which of course contradicts with some other language provided by the legislature about how we are to begin with the presumption of probation, fines and costs, and no jail. But I tie those two together and say, well, if I don't think the defendant's going to be successful, why do I put him on probation? In this instance, I'm going to tell you, there are things that I'm very troubled by. And I don't know how to take this into consideration. I'll just explain it. When I look at CFJ 284 and I look at page, toward the end, one second, page 13. If I have a defendant who has significant mental health problems, why don't I see anything written in that section? Now, I do know that I have a report from the health or social worker who works with the public defender's office, which I do appreciate. It gives me a great deal of insight. But the defendant has significant mental health problems and apparently isn't getting treatment. And he's not getting it on his own. So why do I consider releasing the defendant who says I plan on getting treatment when he hasn't been doing a very good job at that on his own? And Mr. Blazak, I know the answer to my question, so it's kind of rhetorical. Is it easy getting somebody into mental health treatment? No. So the problem here is whenever somebody looks at me and tells me, well, Judge, we have a problem with mental health in the state, that is absolutely correct. Division of powers means I, as a part of the judiciary, I don't create them. I don't create mental health treatment. I'm not the one who determines, no judge determines how much funding goes into that program. Right? The prosecutor's office is a separate branch of the executive branch within the county. The Michigan Department of Corrections works for the governor, and they're the ones who also manage jails and the treatment programs. And the legislature decides how to fund them. Well, unfortunately, we don't have them. So I don't know what to do. I've got a defendant who has mental health problems who isn't getting his own treatment. He's been in and out of rehab, and that hasn't worked. He hasn't continued to take his treatment, apparently, while recognized. Now, there are other things here. I like to go through these, and I think I go through them with a pretty fine-tooth comb. The defendant doesn't work.
This is honestly one of the most honest moments you'll hear from a judge. He flat out says the mental health system in this state is broken, and it's not his job to fix funding, it's the legislature's. He wants to help this guy. There's just nowhere to send him.
Right? Because he's on a disability, which he started in 2008. But he was still able to get a diploma in 2011. I don't know why he's not working. Well, maybe he's not working because he's been using drugs and alcohol since the age of 10. And he's 33 years of age. That certainly isn't going to help his mental health. Probably has contributed to it while his brain was in the period of development. When I read these, and I understand why they put in there, but Like when I read these mitigation reports, we can talk, and it's okay to put these in. It explains how he got to where he's at. He had a really rough childhood. Now, he's got disability, but somehow he's got 5 children, ranging from 10 months to 9 years of age, and he can't work, even though he's got a diploma. And even though he can afford, with whatever he does receive, alcohol, which he's been using since age 10, marijuana, which he's been using since the age of 10, and apparently doesn't use it anymore, but did use methamphetamine for a couple of years back in 2014 through 2017. So, I understand he's had a difficult childhood. So what's the question? How does that apply to a judge? Is it given to me just to strike sympathy? Or is it an explanation? Either way, I can't do anything about that. I can't fix the past. Only the defendant can fix the past. And so far, he's not doing a very good job at it. I can't make him do it. And the legislature and the executive branch don't give us enough opportunities. The only opportunities they give me are coming through Mr. Blazak. It's not that it's not his choice. I mean, he's only got so many tools in his kit bag. They don't work for me. I don't work for them. If they don't give me an option, I can't put you into what you want. Just can't do it. There's only one place I know they have all that treatment. I look here at the event, and it was pretty difficult. The defendant was drunk and sped away in a car with a high rate of speed, throwing gravel all over the place. And when he was ordered to, by the police officers about what to do, he said, "Come and make me. Come and get me. I don't give an F. Fill in your favorite word that begins with F and has 4 letters." Then when he was arrested to lock me up, he continued to say, "Yeah," because when they talked about the argument.
The judge is literally reading this guy's own words back to him from the police report, cursing out officers, cursing out his own mother. This is the part where you start to understand why presumption of probation doesn't automatically mean probation.
They, mean the police officers with the defendant. "Yeah, because she got in my mother effing face." This was his mom. "I belong in a mental institution and don't need to be let out," he said. Then he said he blacked out when he asked about what happened. Fell to the ground. "No, I just blacked the F out," he said. Then when talking about the tree and the vehicle, "I wrapped the bitch around the tree on purpose. I don't give 2 Fs anymore." And that kind of conduct continued throughout the entire process. Allegedly, he told the victim in the case, "I'm taking the vehicle because I pay for it." I don't know how you pay for it under less than $1,000 of disability. So you're not getting the treatment you want on your own, and you're violent, drunk, and you resist police officers, and you become quite uncontrollable. Criminal history began as a juvenile with some disorderly jostling, although it started as something more serious. Marijuana as an adult began in 2013, and he had a couple cases that were dismissed here. But in 2016, there's where we see a trespass and assault and battery, which suggests some more, violence. Then in 2017, you're into methamphetamine and drugs, and you violate probation. In fact, you were sentenced on October 19th of 2017, and you violated probation by November 27th. Now, it wasn't a big deal, but you were already back to using marijuana and failing to comply with your terms and conditions. Well, when you were released from that case in October 2018, you made it about 8 months before getting picked up on some more charges. Now, these weren't big ones, but this operating when out in license means deception. Plus it makes me wonder where you're getting a car. I wonder if you were paying for that one. I don't have any information, but I'll say that it at least applies at inception. Then, while you were, looks like while he was on probation, Mr. Blazak, you see that in CFJ 284, continuing from page 8 on to page 9.
Yes.
Yeah, looks like he would have been on probation for that number 7 of 10. So you violated probation with the same offense. Again, it's only drivable license suspended, but that sends to this court a message of deception. In fact, and that continues when we see 2022, but drinking and driving reduced down to an impaired, but also because I can tell he had no license before, he still had driving without his license. Then he violated probation, and his probation was terminated. And October 11th, 2023, that was only 6 months after being off of probation. And now he's back to committing some more acts of violence. Therefore, he can't control himself and he beats up on people. And that was domestic violence. Then we get to our case here. And we're almost 2 years after being discharged from his probation last time. And now we're back to more of the same. He drives a vehicle without a license that apparently he pays for. So he has a vehicle without a license. We don't understand that one. And he's obnoxious. So what does this court do? We've got 2 intermediate sanctioned cells here. One. And then I got 2 misdemeanors. The law says for an intermediate sanctioned cell, the court is to begin with the presumption of probation, fines, and costs, unless it finds reasonable ground. Well, based upon repetitive acts of violence and drunkenness, inability to control his own mental health needs, as well as his prior probation violations, the court's quite confident that a jail sentence is appropriate here. That's for the R&O. Thus, for that offense, the court sentences the defendant to, I'm going to put him on a period of probation for 24 months.
24 months probation, jail time already served on 2 of the 3 charges, and the judge still tells him point blank to go get the treatment on his own. If you want to see more real sentencing hearings like this, hit follow because this one's got layers.
The court's going to adopt the terms and conditions for probation that are listed on CFJ 145, pages 2 and 3, find those to be well suited for rehabilitative purposes. The court assesses a $68 state minimum fee, $130 crime victims' right fund fee. Now, Tina, there are going to be some other fees for the other charges. I'll cover all those in just a second. As for the R&O, again, this is a intermediate sanction cell, but this defendant needs to understand to quit acting with violence. The court therefore sentences the defendant to 180 days and gives the defendant 94 days of credit. As to count 2, operate while intoxicated, or as a second offender, the court sentences the defendant to the 180 days with 94 days of credit, and again, he's on probation for that offense as well. The court then adds a $50 state minimum fee. The court also adds a $300 court cost, a $500 fine, a $300 attorney fee for the processing of this case. Of course, there's a supervision fee of $30 a month or $60 a month if there's any electronic monitoring. Also for that charge, the court assesses a $100 restitution payable to the Missaukee County Sheriff Department for emergency responses. All right, now, as to the domestic violence, count 3. Well, violence seems to be a pattern, and the court's not limited to that presumption. And, well, he's already served the 94 days, so the most I can give the defendant is by law, 93 days with 94 days of credit. And, Tina, the probation only applies to counts 1 and 2, doesn't apply to count 3. And, again, there's a $50 state minimum fee there. So I'm going to repeat that. 24 months of probation, For count 1 and count 2, they're both 180 days to 94 days with 94 days of credit. And for count 3, it's 93 days with 94 days of credit. $68 state minimum fee, 2 $50 state minimum fees, one $130 crime victims' rights fund fee, a $300 court cost, a $300 attorney fee, and a $500 fine, plus supervision fees of $30 a month or $60 a month if there's any electronic monitoring, and $100 payable restitution to the Wasaki County Sheriff Department. Have I missed anything, Mr. Blazer?
Thank you, sir. Thank you.
Well, it's unfortunate. Sometimes it just doesn't make sense. There is no treatment programming, but I really wish there were. Somebody pick up a phone and go call your legislator. That's not within this court's discretion. I can't order something that's not there. All right. Mr. Hartel's going to bring you 2 copies of one document. You're going to place your initials on one copy and do so. Neither elects nor waives any rights. This document tells you that you have the right to appeal the conviction and sentences in this case. Based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document and return to court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. I hope when you get out, they're able to get you some kind of treatment. You have the right to be considered for release from your probation early at halftime if you're successful. All fines and costs are due within 56 days or a 20% penalty will be added. That 20% penalty will be forgiven as long as you're making payments before the end of your period of probation ends. It's up to you to get your treatment. Don't come here and ask for me to give you something that you could have already taken care of. Thank you. We are adjourned.